This is a video for my administrative law class and for my legislation and regulation or Leg-Reg class, because both have a unit about agency rulemaking, administrative agency rulemaking. And the purpose of this video is just to give a quick sort of big picture overview or roadmap of the subjects that we cover in this type of chapter or unit in the course. I'm hoping that this will help students see what they should be watching for when they read cases or watch lectures and go through study materials like the flashcards, and it will help you fit things together and tie things together. Some students may also find this to be a kind of helpful quick recap review at the end of the chapter before moving on to make sure you didn't miss any big picture stuff and you got the main points of the chapter. So again, we're talking about administrative rulemaking. There we go. So here's our points that we're hoping to cover in this chapter. First, the Rulemaking Authority, and here we're talking about the enabling statute of the agency. So if the agency is going to start promulgating rules, they have to be acting within the kind of scope of what their Congress has told them they can do. We don't want the Environmental Protection Agency, for example, to start making immigration rules or rules about vaccine approval or something like that. So this is a little bit of the are you even authorized to do this, and a little bit of a stay in your lane for that agency. We're also going to have some cases about the rulemaking procedures, and I'm going to come back to this in a moment, but especially about this big distinction between formal rulemaking, which has become very rare and agencies don't like doing because it's so time-consuming and costly and cumbersome, and versus informal rulemaking. But just to watch for that this distinction is very important, and we're going to have some cases about the problem of formal rulemaking versus regular rulemaking. We also are going to have some cases that we call the hard look doctrine, or we have a few other names we use for this. And this is where courts review the substance of the regulations themselves. Now, normally courts they're the judicial branch. They're supposed to try not to meddle in the internal affairs or decisions of the executive branch. So this is different than just someone who's the target of an enforcement action. Instead, this is someone asking the courts if a regulation is completely unreasonable or so out of bounds that it can't be legal for that purpose. So this is more controversial, but sometimes courts do look at the actual substance of the regs to see if it passes at least minimum standards of reasonableness and so forth. More importantly is we're going to look at some cases about how we apply a statute about purely procedural steps that agencies have to go through when they promulgate regulations. I know this sounds boring, but there's a lot of litigation in this area in practice about whether the agency went through the steps and procedures they're going through, even apart from the merits of the rule that they promulgated. How good or bad the rule is, that matters, but also it matters that the agency went through all the steps that it's supposed to. And those rules are found in one section of the Administrative Procedure Act, Section 553, which is, again, purely procedural. And 553 includes some exceptions like guidance memos and interpretive rules. And we have some cases where the agencies are trying to save some steps or avoid going through the procedural requirements of 553 by just announcing that what they're doing is not a real regulation, it's just guidance or just an interpretation. So we get these cases, which, by the way, are an area of uncertainty in our legal system, or the cases go either way, but whether the court is going to agree with the agency or tell the agency, I'm sorry, that this looks like a full-blown regulation, you need to go back and redo the steps. Lastly, in the unit, we're going to have some cases about rulemaking through adjudication. So for my students, this will remind you of first-year common law style rulemaking, where the agency is announcing its policies as cases arise, as they do get complaints or as they bring in enforcement action. So instead of kind of putting out a codified set of regulations that sort of look like quasi statutes. Instead, they're taking things on a case-by-case basis, but then announcing what their policies are in that case, or what their policies will be going forward from that case. That feels a little bit more like the common law approach to making legal rules. And less importantly than these other points, but it's still part of the unit, is ex parte contact. So what happens when a special interest group or a government official outside the agency is intervening or meddling in the agency's rulemaking process and their decisions about how to make rules? So we have some cases about that and some rules that we will get to at the end of the unit. And that concludes our quick introduction or overview of our about agency rulemaking.